Good evening, everybody. Welcome to this STUC organised events, Know Your Rights, organising during the COVID crisis. My name's Dave Moxham. I'm Deputy General Secretary at the STUC. This event has been organised in relatively short order as a response to announcements that we had earlier this week, announcements we continue to have that in view of the very serious and worsening situation with respect to COVID infection, additional workplace restrictions have been introduced. And the first of what may be one of many events which look at what workers, what union reps, and what we can all do to ensure that we meet this difficult situation with the maximum safety and the maximum precautionary approach. It's worth perhaps casting our mind back to the situation some 9 or 10 months ago now, when we first went into lockdown. And much of what we'll be discussing today relates to the extent to which the situation now differs from that first lockdown and where that leaves workers and where that leaves reps. Some of the key questions around whether they should be at work, what work should be going on, what work shouldn't be taking place, what their rights are around that, what their parental rights are around that, how it affects their status with relation to the furlough scheme, and a whole set of questions that have been raised as a consequence of this current crisis. Fundamentally, of course, what we'll also be talking about is not just what those rights are, because very often those rights aren't black or white, but how we organize around them, how we build power in the workplace, whether organized or non-organized workplaces, to ensure that we are in the best possible position in a situation which is, as I've said before, very, very difficult. Now, today's event is broadcast on StreamYard. It's also available on YouTube, and it's also available on Facebook, which is a captioned service. Anybody who posts questions through Facebook, and I'll talk about how you do that in a minute, will find those comments also appearing here. And we'll use the comments, whether they're delivered directly into the StreamYard platform or whether they're delivered through Facebook, to put some questions to our panel, who I'll come on to introduce in a minute. It's worth pointing out that if people do have questions or points that they wish to make, kind of think about this if you use Twitter as Twitter and a half. The question box only accommodates 200 characters, which is a little bit more, but not that much more than a Twitter comment. So if you don't want your comment or your question to be cut off or edited in any way, try and make them fit that criteria. So hopefully people are fairly clear. As I say, use the comments question for comments and questions. They'll be put to our panel at the end, who, as I said earlier, I'll introduce shortly. What we're going to try and do in this 1 hour session, which will be split half between presentations and half between questions and answer, is I suppose to go on a little bit of a journey to look at where we are now with respect to the closure, the partial closure or the non-closure of workplaces, what we should be expecting, what we can argue for, what some of the rights are that surround that. And that first section, which really looks at some of the legal rights, will be delivered by Gillian Merchant, who is a solicitor with Thompson's, lawyer with Thompson Solicitors, a great friend of the trade union movement. We'll then be introducing Sarah Collins, who's an industrial officer with the EIS union, who'll bring that a little bit more into the workplace setting, how we organise and how we agitate around that in the workplace, whether organised or non-organised. And finally, we'll move on to my colleague, Tam Wilson, who works for the STUC for the Better Than Zero campaign. We'll be looking a little bit more about how that plays out in non-organised and precarious work settings. So that's the situation. The last thing that I really have to say before I move on to Gillian is to recognise that there's an awful lot of confusion out there. Last time, the Scottish Government was quite clear, for instance, that non-essential manufacturing and non-essential construction should close. Last time in retail, areas like click and collect were closed in the first instance. And so the regulations are different. And we've heard from a whole range of workers, a whole range of reps, not just in those sectors, but across other sectors, that employers are taking a less cautionary approach, that more people are being required to attend workplaces, even if under previous regulations their work would have been deemed non-essential. We're also hearing serious concerns from workers for caring responsibilities, particularly parental caring responsibilities, about what rights they have, about what happens to them, for instance, when they're deemed by their work to be necessary to workplace activity, but not necessarily deemed to be a key worker in the way that we've come to understand it. And we've had significant confusion about whether workers can be furloughed or furloughed again in the period moving forward, particularly where those workplaces maybe should be closing but aren't being required by government statute to close. So a whole range of questions, probably far too much for our three speakers to deal with, and certainly in terms of its legal implications, a little bit of a minefield, I would suggest. So I'm not necessarily envying the role that our first speaker has, who is Gillian Merchant, who you can maybe bring on screen now. But we have asked Gillian, in the best way that she can, in about 10 minutes, to give us a quick whistle-stop tour of some of the key issues that are coming up in legal terms with relation to the current restrictions and situation we're in. And I'm sure she'll be happy to answer some questions, which no doubt will arise following her contribution, but we will take all the questions at the end. So I'm passing over now to Gillian from Thomson's. Really grateful that you can join us, Gillian, to give us our first contribution. Thanks very much.
Thanks, Dave, and thanks for having me this evening. Yeah, the legal perspective. You know, as is always the case with these things, the way employment law is in the UK, it's really a limited recourse in terms of the rights that workers have in this whole situation. The vast majority of the rules and regulations that we hear spoken about, but from government and politicians, is based on guidance, and even in the circumstances where it is underpinned by statute, it sadly rarely provides any rights that are enforceable on an individual basis, for example, an employee against their employer. However, having said that, what we do have is the current employment and discrimination legislation, which is obviously applicable to this situation as it would be in any other situation. And I think from the broad issues that Dave foreshadowed in his introduction, probably see four categories that I'm going to kind of briefly go through this evening. So working from home, health and safety in the workplace, the furlough scheme, and help for working parents. So first, looking at working from home, I mean, as far as the Scottish Government guidance goes in that regard, it's not really changed recently from what it was in the first lockdown. You know, it's clear that working from home is the default position for those that can do so. And that includes, at the moment, those providing essential services and supporting national infrastructure when they can do their job from home. Where it's not possible to do the job from home, then the employer are required to consider all health and safety measures that they would need to make the workplace safe, such as staggered start and finishing times, the kind of reduction in numbers of the people in the office, flexible working, things like that. And I think it's important to remember for people who are having to travel to work on a daily or weekly basis that work is a reasonable excuse to leave your home if your work cannot be done at home. And people can, and I know at the moment, certainly on mainland Scotland, the COVID protection levels is the same across the board. When it's not, you can cross different local authority boundaries to attend work. in addition to the general working from home guidance, as Dave said at the start, the Scottish Government is clear at the moment that no one should be going to their work if their workplace is closed under the current regulations. So that would encompass something like, a good example of that is like a hair and beauty salon. Like, they are closed. There's not any ways I can think of that they are currently open at the moment. However, there are a variety of different workplaces where they are closed, but they might be open for click and collect, or they might be open for takeaways or deliveries or those kind of things. And I think that's where the difficulties arise in relation to the working from home message. And again, as I said at the start, the working from home message is guidance only. It's not a legal requirement, and the government have written the guidance in such a way that essentially it's left to each individual business to work out with their trade union, if there is one, or employee representatives if there's not, how best to apply the guidance to their circumstances. The Scottish Government have been pretty clear that they won't be an arbiter of what should or shouldn't be done in specific workplaces. In terms of health and safety at work, employers have always got their duty to look after their employees under the Health and Safety at Work Act, and that continues and in many ways is increasing at the moment. The Scottish Government similarly have published guidance that says the ways that they consider the workplace should be, particularly if employees are still attending the workplace. So things like 2 meters distance, good ventilation, the wearing of face masks, effective hand hygiene, and making sure that risk assessments are done, supporting those who are self-isolating, and supporting working from home, obviously, and flexible working where it's possible. It's probably under the health and safety aspect that really the first legal consideration really comes in as to what do you do if you do consider your workplace to be unsafe. And I think the first thing I would say there was, it's not really a legal response, but, speak to your manager, and if not, your trade union rep, about why you consider your workplace to be unsafe and what you can do to make that safer. And then in terms of legal protections, and certainly something that was discussed a lot in March at the start of the first lockdown in trade union legal circles, was Section 44 of the Employment Rights Act, which essentially, without going into too much legalese about it, allows employees not to suffer a detriment if they don't attend work or they leave work because they consider there's a serious and imminent danger. And obviously, that is a very high test. I was looking for an example of that today, and I came across a paragraph in the Public Health England guidance, which was produced in March 2020, and the guidance is in relation to a care home, and it's in relation to a room where a patient has identified as COVID positive, and it basically sets out all the things that should be done. It should be cleaned, it shouldn't be entered for X number of hours, and all of these things that should be done. But then it says, which I think is really telling in terms of just how exposed employees are, it says once this has been completed, as in all the cleaning and everything, the room can be put back into use immediately. So essentially, if everything is done that should be done, a critical work employee asking their employee to return to a room or a place of work like that is likely to be a reasonable management instruction. And there are likely to be many cases where the employer's instruction like this is reasonable from their perspective, and the employee's refusal to return to work because they think they're in danger might not be reasonable from their perspective or from their union's perspective. And it's those types of risks that need to be balanced in these sort of situations. And essentially, in employment law terms, that really leaves employers and employees with difficult questions. Everyone's fearful and doesn't really know what steps to take in the circumstances. And I would always say in these circumstances, the best thing is for employers, obviously, to follow the guidance and set up and implement the protections that they can. They should consult with the trade union, but also they should agree measures with their workforce to ensure that everyone does feel safe in the workplace. Moving on to the furlough scheme, or the coronavirus job retention scheme, to give us its full name. That's been extended to the 30th of April this year. So it's been extended at various points over the strain of the virus. But now it's in force until the 30th of April. And essentially that allows businesses to furlough employees if they can't maintain their role because of coronavirus. And what essentially the retention scheme does is it allows employers to provide 80% of their usual pay, claim that from the government, up to a maximum of £2,500 a month. And employers can furlough employees for any length of time, for any work pattern. They can flexibly furlough now, so they can furlough for half the week and work half the week. The only kind of criteria there is at the moment is that you're on the payroll at the 30th of October. And you're not funded, but you're not in a workplace that's by public funds. So essentially, you're not in the public sector. Employees should have had the opportunity to discuss with their employer what the consequences of furlough would be, because obviously, in real terms, that is a change to your contract of employment, and contracts of employment can't be changed unilaterally. You have to agree to that change. So employers would have to discuss that with employees. And obviously all equality and discrimination laws still apply in the usual way. Certainly in my own experience, I've seen, especially at the start of lockdown, a lot of women that were pregnant halfway through their second or into their third trimester of pregnancy just conveniently been put on furlough, essentially because they were pregnant as opposed to really anything else. And obviously the discrimination laws that apply to them apply in the way that they would have anyway. So as the scheme is now, you can fully furlough or flexibly furlough, and you do not need to put all employees on furlough. Employees keep the same rights when they're on furlough, and they continue to accrue holidays, which was a bit of a dispute at the start of lockdown, but that is really resolved itself, and it's pretty clear now that you continue to accrue holidays at your rate you would have been accruing them if you'd been continuing to work. Similarly, if you take holidays during furlough, they should be paid at your normal rate. And you can be furloughed due to childcare requirements. The coronavirus scheme does allow organisations to furlough staff who cannot work due to the lack of childcare. And I think that's something certainly the STUC have been trying to promote that message of late, because I don't think it's that widely known by employers that staff who have got childcare responsibilities can be furloughed. So just briefly moving on to rights for working parents, and to be honest, I would mainly say that would be for working mothers, because the evidence is pretty clear that if lockdown has affected any group of individuals, it's certainly affected working mothers more than any other group in terms of the double or triple burden of work and care. And in terms of childcare help, obviously at the moment there's no schools, there's no nurseries unless you're a key worker, and the options there therefore in terms of working are pretty limited. I know at the start of lockdown a lot of people tried to negotiate flexible working so that they could work round about their childcare. However, in reality, all that's resulted in for working women is that they're looking after their kids all day and they're trying to work between 5 and 8 in the morning and 8 and 10 at night, which is just not really ideal for anyone. So obviously flexible working when you can get it, the taking of annual leave to maybe cut down days that you're working. You can use unpaid leave, but again, I would say that you'd have to be in quite a secure financial position to be able to do that. There's things available like parental leave, like time off for dependents, that you can access in law as a parent. However, those are, unless you've got specific policies in your workplace, they're generally unpaid, which, can be quite a difficult thing. In terms of flexible working, if your employer is not interested in doing it on an informal basis, you do have the right to request flexible working. However, it's a bit of a toothless bit of legislation, because they can reject it, and there's not really much that you can do about that. The right only extends to requesting rather than having. And I think certainly, along with a myriad of other situations, this is probably one of the things that, coming out of lockdown and looking at changes that can be made about making the workforce more flexible and manageable for different groups of workers in the future. I think this is certainly something that will be looked at. And so from my point of view, that's kind of a bit of a whistle-stop tour of where we're at in terms of the law, and obviously happy to take questions that people might have on specifics, if that would be helpful.
Thanks very much indeed, Gillian. I think you did a pretty amazing job in relatively short time of going through some of those issues, and we've seen some questions coming in already, which Gillian and other speakers will have a chance to look at and hopefully respond to. Our next speaker is Sarah Collins. As I said earlier, Sarah's an industrial officer with the EIS, as well as being a former colleague of mine at the STUC. What we were hoping you'd be able to do, Sarah, is pick up a little bit on some of the issues that Gillian's raised there, and I suppose begin to bring that into the workplace setting and talk a little bit about how we can organise around some of those rights. And of course, as a professional with the EIS who's been in a day and daily battle to ensure safety in schools and colleges and universities, feel free to make any comments that you want to about the education sector specifically. So welcome, Sarah, and hopefully you can speak to us for about 10 minutes.
Thanks, Dave. Thanks a lot for inviting me along to speak today. I'm just double checking that everyone can hear me, because it was going a little bit slowly just when Dave was speaking there, so that's fine. I just wanted to pick up probably from where Gillian left off, and she said something quite key, which is that despite there being rights out there for people to rely on, for employees and workers to rely on, the Scottish Government are not going to be the arbiter in terms of enforcing those rights and in terms of enforcing any of the guidance, the updated guidance in respect of coronavirus. So the question then becomes, well, who is the arbiter and how do we enforce those rights that we do have? Even if it is just in terms of the employment legislation, or if it is in terms of interpreting the guidance that's out there. So I think, I'm going to be speaking from the point of view of a unionised workplace, workplaces, and how they can organise, because the two things are slightly different, although I think that the principles still very much apply. So the first broad thing to say really is that, of course, you've got to know what the guidance is out there, or at least where to access that guidance and rights. Now, there's a plethora of different documents on various different websites, so it can be completely overwhelming for people. I would say that the STUC, the TUC, all of the different trade unions, Better Than Zero, Hazards, have tried to be succinct, different bits and pieces of guidance and different bits and pieces for knowing your rights. So that is the first place to start. But the second place really is in terms of negotiating, because that's what this will come down to. When we're looking at interpretation of the guidance and then implementing the guidance, it is going to come down to a question of who is able to negotiate with the employer and how you manage to do that. So maybe just kind of briefly going through some of the themes that we were discussing, or that Gillian was discussing, in terms of key workers or furlough, health and safety risk assessments, working from home, etc. It doesn't matter what the issue is. The question is, do we know how to effectively negotiate? So, for example, if we take key workers, now I know that there's an awful lot of people in unionised workplaces and non-unionised places where their employer is telling them that they are key workers now. They're being given letters saying that they're key workers and therefore entitled to spaces in schools, for example, for childcare, but also just that they have to attend their workplace. Now, the government have left it to the employer to decide whether or not they are a key worker in terms of the guidance. And the guidance is relatively broad. It has to be said there's 3 categories of key worker, and the third category says that it's all workers in the private, public or third sector without whom there could be a significant impact on Scotland. So obviously what we've got then is Burger King, eSure, car insurance, gardening firms, various different places saying that they are key workplaces and that that Scotland couldn't function without them. What workers themselves have to do is look at the tasks that they're being asked to do and whether or not these tasks are essential and critical tasks that can't take place in their home, from their home. If they're not, and I imagine then that the worker or employee would feel unsafe about the fact that they've been asked to attend the workplace, then the first thing to do is to look at your rights, look at the different websites that we've mentioned, look at your rights and look at the guidance that's out there and get together with your colleagues. Now, if you are part of a union, then hopefully you would have a union rep in the workplace, and if not, then you can contact your union to speak to one of the officers or organisers in the union about getting support for your workplace. Now, this happened a lot in March and April when we had the first lockdown, where employers were saying that they were key workplaces and that the staff had to attend the workplace. When a union got involved, whether it be a union rep or whether it be a union organiser, etc., the employer did tend to reconsider, but it only did that through the workforce themselves getting organised and negotiating with the employer. And what we really need to be doing here in this negotiation is putting forward the fact that the precautionary principle should be used. So obviously your employer in any negotiation will come back with issues that, you know, their profit is going to suffer, that they are a priority, that their sector is a priority, that their workplace is a priority, etc. for them. But we have to start from the point of view that the precautionary principle says that we have to reduce the transmission of coronavirus. And if your workplace does not have to be open in order to reduce that transmission, then it should not be open. Obviously, what might happen then is that your employer is saying you're not going to get furloughed, this will lead to redundancies, this will lead to people not being paid, etc., etc. Or that, well, you can work from home, but you've got to be doing the exact same hours and the exact same basis that you were doing in the workplace, which clearly isn't possible for a lot of people with caring responsibilities, with technology issues, etc. So again, that comes down to negotiating with your employer with the help of your union rep or with a union organiser or officer to try and get a more flexible but a much more reasonable approach from your employer, whereby they are and can access the furlough scheme. And Gillian's obviously outlined some of the ways that they can do that, including the flexible furlough scheme. That there has to be an element of flexibility in working from home. And the stronger your workforce is in terms of getting organised and speaking to all of your colleagues and making sure that your asks of the employer are evidenced, are well evidenced, then the better and easier it is for you to actually go into these negotiations with your employer. So for example, I work for the EIS, which obviously is Scotland's biggest trade union for the education sector. Now, it's a well-established union. The whole education sector in Scotland is very well unionised. It's lots and lots of members. Most people who work in the education sector are a member of a trade union. That gives a lot of strength to members and a lot of strength and credibility to the union itself when it's negotiating or when union reps are negotiating with the employer. So if I can give an example of where this has been successful, because I think it's good for us to show some successes in organising, even if it is in well unionised sectors, because it shows what is possible for non-unionised sectors as well. If we take, for example, the current issues in terms of schools, apparently being closed. We know that there are an awful lot of children who are still being sent into school at the moment, or who were being sent into school this time round, partly because of the fact that employers had widened their interpretation of key workers. So whilst the first time round of first lockdown, key workers were limited, who was classed as a key worker was limited, and therefore the children that were sent into the schools for childcare and learning was limited numbers. This time round, employers are sending in letters left, right and centre saying that they are key workplaces and therefore their employees require spaces in the schools for childcare and learning. Now, because the workforce in the schools is well unionised, they're in a position of strength to go and negotiate with their employers to say that they've got to push back on these letters as well, and to reduce the number of children that are in the schools, because that is about the precautionary principle of reducing the risk of transmission. So in England and Scotland, we've obviously got a relatively good public sector bodies that are listening to the union, that are listening to the union representatives, that are listening to the union members in the schools, etc. In England, they've had a much bigger fight on their hands. And I think Gillian mentioned the use of Section 44. And Section 44, is, in terms of the health and safety legislation, is where a person feels that they cannot go into the workplace or has to leave the workplace because they're in serious or imminent danger. Now, that protection, that legal protection, can be scary for an individual to use, but it's when the strength of the workforce comes together, when there's a collective of a workforce using those kind of legal protections, that's when they are most fruitful. That's when people feel a lot braver to use them as well. And the situation in England in education saw, over last weekend, saw thousands of primary schools and secondary school teachers sending in letters to their school saying that they felt in serious and imminent danger if they had to return to the workplace. Now, they used that Section 44 legislation, which is an individual protection, but they used it collectively. And by doing that and having the strength to do that, because it was well organised with the union as well, it probably forced the U-turn of the UK government on the Monday to then close the schools. So now what we need to be doing in every single workplace in the education sector is ensuring that that guidance then is followed, that these workplaces should only be opened for absolutely necessary for vulnerable children and the children of key workers, and key workers being our definition of key work, which means that there's a critical or essential service being carried out by that workplace. Now, workers in any kind of workplace, wherever it is, or whoever the employer is, have to be getting together right now, whether it's on WhatsApp, emailing each other, phoning each other, etc., making sure that they've got at least one person that's going to be their representative, their spokesperson. Hopefully that would be a union rep if they are unionised, to make sure that they are quite clear, all members are quite clear what the guidance says, what the legislation says, and how they can enforce those rights. And if there's something that they're not happy with or that they think they have to change, then people are getting together, they're organising so that they can be in a position of strength to go and negotiate with their employer. If we take another example of working from home, and we've touched on this with working parents as well, in well unionised, well organised workplaces and sectors, there is not so much of an issue as staff feeling like they have to be on call all the time and their normal 8 to 5, 9 to 5 work whilst having caring responsibilities. Because what you do in a unionised sector is go and negotiate with the employer that there will be more flexibility, that the employer will allow for the fact that there has been a major change and disruption into the working environment of the person, and therefore their working day, their working hours may have to change, and that is accepted then by the employer. It's not only in unionised workplaces, obviously, that that you can organise. You can, of course, organise in non-unionised workplaces, and Tam will come on to that as well. But the key thing for unionised workplaces is to rely on your union rep, to make sure that your union rep has all the evidence and knowledge of what's going on in your workplace at their fingertips. So if you do have a problem at work, don't just sit and think, you know, there's no alternative, there's no way to change this. Get in touch with your union rep, make sure that they have all of your asks, all of your demands for the negotiations with the employer. And if you're in a union but you don't have a union rep, then get together with your colleagues, elect a union rep, get support and advice from your trade union. Everybody obviously is busy right now. There's people that are stretched and resources are stretched absolutely everywhere, but it's really, really key to get that support and advice from your union. It's also key to make sure that your union is fully updated on what is happening in your workplace, whether it's a positive or a negative, because unions all like to have good success stories as well. We like to share best practices, to share times when their you know, negotiations and organising have been successful. So please do share those stories with your union, as well as any problems that you've got, as well as any examples where the guidance isn't being followed. Because trade unions all sit on governmental bodies as well, or review groups around coronavirus right now, and it's really, really important that trade unions are able to raise these issues with the government, because we don't want to just be in a situation where the government, via the press or however, are saying this is the protocols, this is the guidance, this is what should be done, and we've got thousands and thousands of members out there knowing that that isn't happening, knowing that the guidance isn't being followed. Trade unions need to be in a position to raise that with government as well. So don't sit back and just think, you know, there's no alternative, we can't fix this, I'll just have to get on with it, whether that's continuing to go into work, not being furloughed, or whether it's working from home and you're ending up working 15 hours a day and not being paid for it. Please do get in touch with your union and your union rep to raise it, because it's really, really important. I think the last thing I'd like to say is just in terms of some of the kind of wider issues that this organising can do. And I think we've got a real opportunity here to put forward some more general trade union demands during coronavirus, during the coronavirus pandemic. Obviously, trade unionists have been arguing for pay rises for key workers, for public sector workers, etc., for a very long time. This gives us the opportunity to evidence the key work and valuable services that people in those workplaces are contributing to society. So that kind of organising work that we're doing on the ground isn't just for the next month or 2 months or 3 months or however long the pandemic is ongoing for. It has to be sustained organising work that allows us to continue to raise these kind of broader macro demands of pay rises or better mental health support for workers, more NHS funding, no privatisation, etc., etc. So if you're not unionised, if you're not in a unionised workplace, etc., Tam will be speaking about how to organise in those sectors in terms of the nuts and bolts of it. But I think that the principles definitely still apply, and it's really important that we get all of our issues out there and heard, and that we start organising on them in order to actually have some successes.
Thanks. Thanks very much indeed, Sarah. That was really, really enlightening. And maybe just to underline one of the points that Sarah made, we're not in a static situation here. On a day and daily basis, trade unions and the STUC supporting trade unions are arguing with government to close some of these loopholes, to improve some of the guidance. So those concrete examples of where it's going wrong, as well as some of those examples that Sarah mentioned of where it's going right, are absolutely vital. Now, because of time, I'm going to bring in Tam quite quickly here, but just to say to folk that we will run this long enough in order to answer some of the the key questions that have been coming in, and thanks for those in the comment box. But I'm going to move on now to Tam. People who for people who don't know, Better Than Zero is the STUC supported, sponsored organisation that particularly works with precarious workers with non-organised workplaces in order to ensure that we begin that process of supporting people to organise in some of those difficult areas, such as hospitality, call centres, and other areas. So we thought it was important to get a perspective from somebody who's involved in hopefully winning sometimes, but certainly fighting the battles that have to be fought in unorganised workplaces as well as in the organised sector. So Tam, welcome. Look forward to hearing what you've got to say.
Am I back? Yeah. So yeah, hi. As Dave says, my name's Tam. I'm from the Better Than Zero campaign. I'm just going to go through some of the tactics we used and how we applied them during the first lockdown. Then go through some of the issues that we're seeing come through just now, and then a little bit on what workers in precarious and casualised work can do right now in the first instance. But as Dave says, I'm from the Better Than Zero campaign, which is the STUC's campaign on precarious and casualised work, focused on traditionally ununionised and unorganised sectors. And our focus is building collective identities amongst non-unionised workers so they can respond to issues in their workplace. And so we give workers the tools, tactics and confidence to recognise and exert their power as a collective force, building up that confidence as we go on. Now, when workers get in touch with Better Than Zero with issues, they don't need to be fully formed in terms of how they want to take things forward or in terms of what they want to do at the next step. They also don't necessarily need to be well versed in what a union is or what the bureaucratic elements of what a trade union is. Lack of understanding of unions is definitely not a barrier to working with Better Than Zero. Obviously, our end goal is to increase union density and have more union branches, but we aim to break down some of those barriers so that people who are engaging with us don't feel put off. And we often try and reiterate the fact that the issues that people are coming forward to us, often on an individual basis, are being felt by workers right across their workforce and across the whole workforce and in their sectors. So over the course of the pandemic, the tactics of what Better Than Zero have used have had to change somewhat, especially considering there's such a range of different issues being experienced. But our fundamental principle has remained the same, and that's when issues come forward, we try and figure out whether these issues are being experienced collectively across a group of workers, and whether we can pull workers together to move forward to challenge these collectively, building more confidence and bringing more people on board. What we've done as a sort of first protocol is, regardless of the issues that are being experienced, is encourage workers to get together in groups. Now, what we're recommending is WhatsApp groups, but whatever is suitable to the particular group of workers and whatever benefits them. Now, getting workers together in WhatsApp groups, particularly ones obviously that are on board with challenging and raising some of the issues that are being discussed. It's helpful in terms of getting everyone on the same page and on the current situation, figuring out what management are asking staff and what is being told to different workers, and also collectively understanding how people want to take things forward. Now, we both support workers in terms of taking things forward internally and externally. Now, internally could be in terms of writing letters to management or putting a position forward to management. And externally, if some of that internal stuff isn't working, is to put things in the public domain, getting media involved, drawing more public attention toward things that are being experienced by these workers. Now, the calls that we put out on public issues helps gather support from the public on things being discussed, but also helps build up the confidence of the workers, so they know that they have support externally from the issues that they're experiencing, and it helps force employers into a corner often where they have no choice but to respond positively toward the workers. Now, I'm just going to label a couple of different examples of the way that we used this during the first lockdown. and different ways in which it's been used. So one was the Pure Beauty, which have a number of different sites across Scotland. Now, at the first lockdown, the workers at Pure were asked to sign new contracts, sort of lowering their conditions, putting them onto 0-hour contracts, denying a lot of the rights that they had already existing within their work. Now, rather than signing the new contracts, the workers got in touch with us, and we pulled them together collectively. And after a bit of toing and froing with the workforce, we managed to, and the workers managed to, get the Pure to keep them on the same conditions that they were currently on, and then furlough the workers so that they were being protected going forward. Another example is Cineworld. So Cineworld, a number of people had taken part in Better Than Zero training sessions that had taken place before, and those people that then formed the Cineworld Action Group. Now, the Cineworld Action Group was a lot more about building that collective strength across the whole of the UK, so that they could challenge the company. And I mean, the group started off with just a couple of people, and then I think now it's sitting at around about 1,000 or 2,000 people that are in that group, and it actually reaches across different cinemas as well. And although there's been some bumps in the road and not everything has gone massively according to plan, that pressure that was being asserted managed to get a lot of the workers re-employed who had been sacked, and managed to get people furloughed for longer than they were expecting to be furloughed or they were initially promised. So there was that pressure definitely had an impact in terms of how Cineworld took things forward. And then another example is Koya's Cafe in Glasgow. Now, there was a number of workers who'd been made redundant from their job, and they were owed a significant amount of money. I think it was around about £300 or £400 per worker. Now, the workplace had just sort of washed their hands of the workers once they'd let them go. Now, we recognise that we can't actually always get everybody's jobs back, but we were able to put public pressure through the media and through Facebook posts and through getting other people involved to get these workers their money. So as soon as that public pressure was put on, the workplace sort of caved very quickly in terms of to their demands. Now, some of the issues that arise from organising is building that confidence. Now, we recognise that it is scary raising your head above the parapet to challenge some of the things that are happening with bosses. Now, we don't deny the fact that there can sometimes be repercussions to doing this sort of stuff. But that's why we really focus on building that sort of collective within workforce, both in terms of demonstrating the power that a collective group of workers have, but also so that workplaces are less able to pick on people individually, so that they can exert that power and make their points known both publicly and internally. So we support workers in being able to sort of speak to their colleagues, and if people sort of don't know how to have those initial conversations with the workers, they can get in touch with us as well, and we can sort of help sort of tease out those initial conversations that they can have to recognise who might be on side and who won't be on side. So that was largely about the first lockdown of the pandemic. Some of the issues that we're experiencing now is in regards to, as has been mentioned before, non-essential workers being forced to come into work in unsafe conditions. Now, we've had a range of different examples of this coming through. We've had people from used car dealerships, quite a few different call centres. We've also had the issue of a popular homeware store that have purchased fridges so that they can begin selling milk to reclassify themselves as essential. And then we have the other issue of click and collect services being still open, as Dave pointed to earlier. Now, the click and collect is slightly different in that the Scottish Government still permit that to be open, but that's something that I think we can begin to put a bit of pressure on. Another example that's come forward in recent days has been at JD Sports. Now, the JD Sports have all closed down in terms of their public-facing side, but the workers have been asked to still come in to fulfill online orders. But actually, as the workers have been asked to come in, they've scrapped a lot of the health and safety restrictions that were in place initially within the workplaces. with management dismissing some employees' concerns and claiming that workers aren't COVID regulators, so it shouldn't be of their concern to try and define what is and what isn't safe. So here's just a range of examples of employers that are clearly taking advantage of the ambiguity of what is classified as essential and non-essential, to really prioritise profits over the health and safety of their workforce, but also of the wider community. And what we'd like to see, and what we are trying to do with a lot of this, is both build up the collective groups within these individual workplaces, but also to put public pressure on these non-essential workplaces to close immediately and to furlough their workers. We both want to put pressure on the employers, and we want to put pressure on the Scottish Government and UK Government to take a stand on what these employers are doing. Now, a major reason why, or in our perception, a major reason why these employers can exploit their workers in this way is because these workers are non-unionised and they don't have a union to depend upon. So that's why at Better Than Zero we want to build the bones of a collective within these workplaces, so we can challenge these exploitative conditions going forward, but also to help build up what we look like at the other end of this, where we have collective groups, so that then we can start exerting our power and making more and more demands of what people should be getting going forward. Another part of another campaign that the Better Than Zero project is involved with is the call centre collective. So the call centre collective was started about 6 months ago now, and it was started up by the CWU, but involves a range of different unions and different actions that are taking place. And basically we use Better Than Zero's tactics to sort of put pressure on call centres to ramp up their move to working from home. And we believe we've been quite successful in doing that going forward. But because call centres are less of a public-facing form of work, more call centres are trying to get away with some of these tactics. One of the issues that we're sort of rallying around within the call centre collective is the risk assessments that take place, because obviously some call centres are essential and do need to be open, although we would argue a lot of that still could be done from home, and other parts of call centres aren't so essential. But one thing we're rallying around is risk assessments. Now, a stipulation for call centres reopening again was that they should have robust risk assessments and they should be publicly available, so that people can really understand what's happening within these workplaces. Now, that wasn't done on as large a scale as we would like, and we would want to ensure people's safety. But also, a lot of these places haven't taken into consideration the new variant of the virus, which is far more highly transmissible. So we want to put pressure on these call centres that you could argue maybe have some justification for being open to publicise those risk assessments, so that we can fully understand what they're doing to protect their workers, because some of the examples that we're hearing come through right now certainly aren't doing so. So in terms of what workers should do now, I mean, I'm repeating myself here, but speak to your fellow colleagues and organise them into a WhatsApp group. If you're a bit self-conscious about doing that in the first instance, you can come to us and we can help support making those initial steps. But also, if you've already got a group of workers and you want us to be involved in your WhatsApp group, you can get in touch with us as well. We will help you work on help you decide what collective demands could be and how you can sort of push them to your employer. But this could be through a whole range of different issues. This could be demands for workplaces to close. This could be demands for staff to be furloughed, for an increased health and safety measures in their workplace, accommodation for people who have childcare or caring responsibilities, or for people who have who are maybe supposed to be shielding but aren't given any assurances from their workplace. And as I've said before, this pressure can be internal, from the workers inside the workplace, or external, supporting public campaigns, speaking to press, and we can do this both anonymously, or if it's a big enough group of workers, we can do this collectively and publicly. But no matter what stage of organising you're at, or how well versed you are in the ideas of Better Than Zero or trade unions in general, you can get in contact with the page. We're open to assist workers to collectivise and help support you through the next stages, however you want to take things forward. We're about supporting to give you the tools to take things forward rather than telling you what to do. But it's important not to suffer in silence, because many workers are feeling very similar about the issues that are being brought forward about health and safety during the pandemic. It may sound difficult or unachievable in many instances, but these techniques, as I've iterated before, but also in many other cases, have been successful in terms of achieving victories for workers throughout the pandemic who have had no union experience beforehand. And by talking and collectivising with your colleagues, we can change the way that our workplaces are run and the decisions that the government make about our futures. So Better Than Zero's social media channels are all open for you to message, and we'll help you take things forward there.
Thanks very much indeed, Tam. That was, again, incredibly informative and useful. Now, we do realise that we've taken longer in our presentations than advertised. I hope people nevertheless found it interesting, and we've been inundated with questions. So we're going to try and take those for about 15 minutes. I'm going to run through them in groups of 2 or 3. Please, if we don't answer your question, because we've definitely got more than we can deal with, email them into info@stuc.org.uk. We check that mailbox by the hour, and so if you've got a question that we don't cover, please email us so that we can. But I'm going to ask if the panel can be brought back now, and I'm going to ask some of the questions that have appeared in my chat box. Welcome back, everybody. Thanks very much for that. Now, I'm going to kick off with questions that I suppose would be described as more legalistic to start with. And therefore, I'm going to go to Gillian first, although I'll tell you a secret now. Sarah Collins knows quite a lot about this stuff too. And I'm sure Tam has come across quite a lot of it, even though he wouldn't claim, I don't think, to have a legal qualification. So a few questions to start with. Hopefully some of them can be dealt with relatively quickly. So Gillian, I'm going to read out 3, which probably won't be maybe very popular with the people who are doing the back end of this. But the first question I'm looking at is around section 44. And the question is, does section 44 not refer to removing yourself from the area but not the workplace? So that's really about whether it's the danger of the area rather than the whole workplace that section 44 refers to. The second, again, a legal question, is if an employer refuses to furlough you and you therefore end up taking unpaid leave, are there any grounds for arguing indirect sex discrimination? And just to complicate it even further for you, in relation to flexible furlough, how flexible is the furlough? So this is a question. I think most people understand that employers aren't allowed to put you to work while you're on furlough. But I think this is a slightly more detailed question about whether an emergency arises and your flex furlough isn't absolute, but it's flexible, or whether it's reasonable for an employer to call you out for an emergency. So that's 3 easy ones to start with for you. I'll go to Gillian first, but if Sarah and Tam have anything to chip in terms of what we might do about the situation once Gillian has spoken to it, please feel free to chip in. Over to you, Gillian.
Okay, thanks. Okay, so in relation to section 44, the legislation basically says that you can refuse to return to your place of work or any dangerous part of your place of work. So it's either or. I mean, I think if you work in a place where, for example, I'm trying to think of something that would be, so if you were working at a specific machine where you thought that you were too close to other employees, for example, and you weren't people weren't wearing masks or they weren't doing the 2 meter distance, then it might be possible that you could work on a different machine that did fulfill the criteria, but not that particular one. But if it was just a general concern about the unsafety of your workplace, then I think that would cover much more general matters. So it's an or as it's drafted, and it's, I think it's interpreted quite widely as well. So I wouldn't worry too much about that. In terms of refusing furlough and indirect discrimination, this is a case that I have tried to run in terms of particularly workers who can't work from home due to the nature of their role, and have had like holidays taken off them, or have been forced to use holidays, or have had toil balances wiped and things like that. They've not been hugely successful so far, mainly because indirect discrimination can be justified. So I think in the circumstances of the cases that I was dealing with, there were particular justifications that would probably allow the employer to have policies that do indirectly discriminate against women. However, each case should be looked at on its merits, and it is certainly an argument, that I've got an interest in running, and I'm acute to that. So I think if you've got some particular issues, don't hesitate to get in touch. And in terms of the flexible furlough scheme, I mean, obviously, as Dave says, the furlough scheme is pretty clear. You shouldn't be working when you're on furlough. And I think that just really comes down to how detailed and clear the furlough agreement is that you've came to with your employer. Is that if you're covering an emergency situation, or there's a rota for on call, that should obviously be in your working time and not in your furlough time. So I think it's just, if you think there are situations that are going to arise like that in your workplace where you might be expected to work when you're on furlough, really that's more of a difficulty for your employer than it is for you, because your employer shouldn't be claiming money from the Chancellor of the Exchequer while also ensuring that you work at the same time. But I think the root of that comes from employers being unclear about the expectations.
Thanks, Gillian. Is there anything, Sarah and Tam, and bear in mind there's lots more questions, but is there anything you want to add to what Gillian said on those three questions?
Not really, other than I suppose on the last question, how do you say no to your employer? That's probably the next question that the person would ask, is how do you say no, I'm not doing that? And it would be back to what Tam and I have outlined before, that you know your rights, you know where to access the guidance on furlough, you know where to seek support and advice, whether that's a trade union representative in your workplace, or trade union organiser or officer, or better than zero if you're not unionised, and then you are making that approach to your employer to say, well, no, I won't be carrying out this work because I am on furlough, then it's about putting a bit of pressure on them to essentially either cancel your furlough or cancel that bit of emergency work that they've asked you to do.
Thanks for that. Tam, anything there?
Yeah, just to say that we always think of the law as a tool to be used, but not what to be completely depended upon. So if these are issues that people want to organise around, whether they're in unionised or ununionised workplaces, if you can build a collective response around certain issues, then the legal framework isn't necessarily as important. We can challenge some of this stuff. We can put pressure on employers, whether it is legal or not in some instances. Yeah.
Okay, thanks very much. I'm now going to ask three more questions, but it may be that each of our panelists want to kind of pick a particular question. It might be kind of obvious where I'm going with this. So someone just asked a question and they're saying HEI, and I'm assuming that means higher education institutions. So the first question here is, HEI is happy for admin to work at home. In months to come, when we see some normality, would HEI, higher education institutions, I think that's what it means, be able to force you to return to campus? Yes, it does mean that, without having vaccine. This is from somebody who would prefer to work from home until they receive a vaccine. So that's question number one that I want my panel between them to deal with. The second one is, I think, slightly more straightforward, but I want to ask it anyway because it's an important one. If one of the essential workers had childcare issues, could they ask any employer about being furloughed? So that's a general question about whether essential workers can ask the employer to be furloughed. And the third question is a more open one and probably, well, definitely directed at Tam. My company does not in general have 0-hour contracts, but it does use contractors and as when and agency during normal times. But how could my union support your campaign, Tam? So that's about a company which I think is unionised, but clearly has contractors that use 0 hours contracts. So I'm going to start off with Sarah, who can choose to answer whatever she likes out of that.
Well, I'll do the Higher Education Institute one because it's a really good question and it's come up in a lot of the local associations and college branches that I deal with in the EIS. And the question really is around whether or not they should be returning to the workplace en masse whilst the vaccine hasn't been prioritised for educationalists and the vaccine hasn't been rolled out there. This does, to be honest, come down to a bit of an organising question as well, because first of all, the guidance obviously is that the vaccine will be given out on a prioritisation list to healthcare professionals, care professionals, elderly, etc. So that obviously doesn't mean that those working on a higher education campus, for example, will be part of that priority group. So the question then is, do we return to the workplace whilst the vaccine is still outstanding, whilst there's still a number of people not vaccinated and therefore the vaccine is not necessarily effective? The government are saying yes, that is their view, that is what's going to be happening as long as the risk assessments are there and they're updated and implemented, etc., for when workplaces do reopen. It's a negotiation between the government and unions at the moment nationally. It's certainly a conversation anyway that's happening at the COVID Education Recovery Group in terms of whether or not workplaces should reopen before there's the opportunity for staff to be vaccinated. So at a local level as well, obviously that kind of negotiation and organising of the staff has to happen too. Whether it's about returning to the workplace before vaccine or whether it's about returning to the workplace whilst in level 4 or level 3 of the restrictions, whatever it is, the key point is still that staff have to get together and seek advice from their unions or from Better Than Zero about this and seek advice about how to negotiate locally with their employer on that basis, but also again to feed in that sort of information and feeling from the members to the union nationally, because the unions are sitting on these national groups. It's really, really key that members and all workers really have their voices heard on those groups and what they're actually asking for. And if that is that a certain workplace wouldn't open until staff are vaccinated, then that should be heard and discussed.
Thanks very much indeed, Sarah. As time moves on, I'm being more directive with this. So, Gillian, I'm going to ask you to answer the 2 questions now. One is, can you request to be, the one I iterated earlier, can you request to be furloughed? If you're an essential worker with childcare issues. The other one is, can you request to be furloughed? And does this apply to those employed by local authorities?
Okay, so in terms of, yeah, you can. I mean, basically anyone can be furloughed for childcare issues. So if you've got childcare concerns because of schools not being opened or nurseries not being opened, then you can be furloughed. However, if you are an essential worker, the chances are you should already have childcare provisions, as Sarah spoke to earlier, in terms of there's nursery places and school places available for essential workers. So in those circumstances, it might be more difficult to be asked to be furloughed in relation to childcare if you actually do have childcare available. However, this is all a bit of a mess because some local authorities are requiring like both parents to be essential workers before they'll give a child a place in the childcare. So it kind of basically depends in terms of what is available and essentially whether or not that's something that you can access. The only other thing I would say about essential workers is a lot of essential workers are likely to be funded out of the public purse, and furlough doesn't apply to those organisations. So if you were to work in local government, for example, I think that was part of the question, or another question. No, you can't request to be furloughed if you work for a local authority.
Thanks very much indeed. I would just add, but it's a small percentage of examples. There are certain commercial functions that local authorities do, which might put them in the furlough category, but only, as Gillian implies, only if they're not funded out of the public purse. Tam, do you want to answer the better than zero question, and then I'm going to ask one short further round of questions before we wrap up.
Yeah, I was just going to say that. So different unions and different branches in particular have different approaches toward whether they consider agency workers to be part of their union activity or not. But we would definitely encourage agency workers to join the same union which is representing the rest of the workers within the workplace. And if you're a fully contracted worker who's a member of the union, we would be arguing that they should be going back to their branch to try and make sure that they can accommodate representation for the agency workers. Now, obviously, different workplaces have different approaches towards this. But if you're thinking about this question within your own workplace, I would recommend that you speak to your branch about whether it can include engagement with those agency workers, and then maybe have some conversations with those agency workers about the union activity that takes place within your workplace and encourage them to join, etc., etc. And if that isn't, for whatever reason, possible from within your workplace, then get them to get in touch with Better Than Zero, and we can, I don't know, start asking, depending on what the workplace is, it's obviously dependent upon, but we can maybe start forming a collective group within those agency workers, because we're in contact with a whole range of different agency workers and are trying to build up some collective identity across agency as well.
Thanks very much, Tam. And as I say, with the view on the clock, I still want to ask two more questions, which I'm just going to chuck out there, and people can answer, or our three panelists can answer as they wish. The first, I suppose, may be quite difficult to answer. When we have teams of workers and the company are sticking to the bare minimum with regards to self-isolating, if one of the team tests positive, what would best practice be for the whole team? And the second question, quite different really. The person asking the question has 2 autoimmune diseases and other health concerns. Will unions support members who are reluctant to get the vaccination? So, who shall I pick first for that? Gillian, do you want to pick one or both of those, or have a go?
I mean, in terms of the self-isolation one, I mean, obviously that none of that is really legal in its nature. However, the one thing I would say is, if someone has tested positive for COVID, if the system works properly, they should have had an extensive debrief with track and trace, and they would be able to provide track and trace the information with who they've been working close to. So if you're in a situation where you've tested positive and you work closely with 5 other individuals, it's likely that those 5 other individuals, if the system works properly, will get a call from track and trace and are told to self-isolate. However, if that's not happening, then obviously the circumstances is more difficult, because if the employer is not supportive of you self-isolating, then that does get into difficulties in relation to pay and what your status is over that time. But I would hope that in those circumstances there'd be pretty clear public health guidance provided.
Thanks for that. Sarah, do you fancy picking up the vaccination question? Because it's not an easy one for sure.
No, it's not. But I suppose the principle still is that, for example, if you've got guidance from your GP, if you've got your own medical advice, either from GP or from an occupational health therapist, etc., then the union representative is there to try and support you in getting your point across to your employer, whatever that might be. And certainly, if your medical guidance says that you should be exempt from the vaccine, then you would hope that the employer wouldn't raise issue with that if that's what your medical advice is. But if the employer does raise issue with that, then like any other issue that you might have in the workplace, then your union rep would be there to support you in any meetings that you had to have with the employer around that.
Thanks for that, Sarah. Now, I am aware of time. Tam, I don't know if there's anything on those particular questions that you want to pick up, and if not, maybe just give us a couple of final words anyway, yeah?
Yeah, well, just to say on the issue of people testing positive, now I'm reluctant to name the particular employer just because we don't have all the evidence in our hands on this, but we've heard cases of employers encouraging workers not to get tested because they're worried that they have the virus, and then once they have then went and got tested anyway, I found out that they've had the virus and they've shut the place down for 7 days for a deep clean, but having people working on a different site in the meantime. Now, these are the sort of things that sort of need to be exposed. So if you're in a non-unionised workplace but are nervous about bringing forward this sort of thing publicly, then these are the sort of things that you can tell us about. And if you have any evidence of this sort of stuff taking place, then this should be in the public domain. And if we can keep that anonymous, the bigger the workplace, the easier that is to do, of course. But you should definitely speak to people. And if you speak to us, nothing will leave our chat box until you have decided that you're happy for it to leave our chat box. So if you're just wanting to sort of raise some concerns but aren't necessarily sure how to take it forward, then definitely get in touch with us around that sort of thing.
Thanks so much, Tam. And just because we do have to sign off quickly, I just wondered, Gillian and then Sarah, if you had any final comments you wanted to make or any reflections on things that you've seen in the chat box.
On you go, Sarah.
I just have a little quote that I'd like to share that's actually completely plagiarised from another union organiser, so it's not my own, but it is that a trade union is not a service that you buy, it's a power that you exercise. So similar to what Tam said about the law, that's a tool that's there. The union, the strength of the union is essentially in how brave you and your colleagues are, and in how well equipped you are in knowing where to access your rights, knowing where to access advice and support, and then knowing how to effectively challenge your employer. And the challenge doesn't have to be a massive negative thing. Often it can actually work to the employer's advantage as well, or certainly it can make the workplace, even if it's working from home, it can make your workplace much better place to be as well. So don't be scared that what we're saying is, all a negative in terms of challenging your employer, but it is just about being a bit brave and knowing that your rights are there to be accessed, to be enforced, and then speaking to your other colleagues as well about how to do that. So the power is with you and with your colleagues in the workplace, and please do use it.
Thanks so much, Sarah. And Gillian?
Yeah, I mean, I just think Tam and Sarah, we've covered it really, that the law, in these circumstances and in many other circumstances, is a tool of last resort when you've got an organised and well-recognised trade union. And I think that is very apparent in this situation, and that workers across the country are much more likely to be able to secure redress through organising collectively with their unions and making a difference in the workplace than going through a legal process, which is likely to take, given the current coronavirus delays, years and be really stressful. And I just think that if there is ever a time to join a trade union, it's now. So if you're not a member of a trade union, I would strongly urge you to join and get active and join collectively with your colleagues.
I couldn't think of a better way to finish an organising session. Listen, I hope people watching and people who come to watch this later have found that useful. We understand that even in the hour and 20 minutes, slightly longer than expected, it's very, very difficult to cover all issues. But I'm incredibly grateful for some of the questions that we received, which I think did enable us to tease out both the legal side, but also the organising side of what we need to do in the current situation, but also in the months ahead. I'm quite certain this won't be the last of these type of events that we hold, because I think they're really vital in the current circumstances. encourage anybody who didn't get their questions answered or thought about a question later that they'd like to see answered to post it to the STUC info@stuc.org.uk. Very, very grateful for people attending. Very, very grateful to our panel of speakers. Keep safe, everybody. Keep active. Keep organising. And I hope the rest of your evening is well. So from me and the STUC and our panelists, thanks very much and good evening.